New York Times reporting on the team that's looking at Judge Aileen Cannon. That's the judge who will preside over former President Trump's classified documents case. And apparently she has little experience running criminal cases and may not be ready for a potential trial with a former president. According to the paper, in Cannon's over 2-year tenure, just 4 of the 224 cases the judge has been assigned have gone to trial. Those cases resulted in just 14 days of her sitting as a judge in a trial. Lawyers who have appeared before Cannon describe her as, quote, generally competent and straightforward, as well as, quote, someone who does not otherwise have a reputation of being unusually sympathetic to defendants.
Unless they're Donald Trump.
However, they also said, quote, she is demonstrably inexperienced and can bristle when her actions are questioned or unexpected issues arise.
Like the 11th Circuit that basically said, congratulations, your ruling has undermined the foundation of American constitutional law.
There's that.
So you take that with the fact that, you know, some judges have a lifetime's worth of experience. She has about a lunchtime's worth of experience, and she's about to hear, unless somebody intervenes, she's about to hear the most important criminal case in U.S. history.
And a complicated one. One that involves classified information as evidence, attorney-client privilege, evidence that came from lawyers about their own client. You would have to be able to pick a jury of unbiased jurors about someone like Donald Trump, who's probably the most polarizing figure, certainly in my lifetime. So it's an enormous challenge that she faced. And we did this thing with the Times Research Department where we went and found all 224 of the criminal matters that have appeared before her. And we went through on the online docket to see which ones went to trial. And the research department at the Times did this tremendous job, and working together, we were able to find these 4 cases.
Right.
And then in the 4 cases, we were able to figure out how many days those trials went. So if I remember correctly, one trial was 5 days, a few were 2 or 3 or 4, and it added up to this small number of about 2 weeks
14
of
days.
Trial experience. And look, you know, federal prosecutors and lawyers will tell you all sorts of things about all, you know, the law and everything, but they say at a very basic level, experience is really, really important, especially if you're doing
I gotta say, Mike, I understand this was assigned randomly. It's what they say, it's assigned randomly. Again, in my experience, it's a very limited experience, you know, there would be a discussion. And if a federal judge or even a state court judge got a really complex case that they just weren't qualified to handle, there would be a discussion, and the judge would say, you know what, this is, for now, this is above my pay grade. This is too complex. Let's move it to another division. I'm just curious, again, with and just forget her disastrous ruling where she was humiliated. Forget that. I'm shocked that this continues to move forward, and she's not recusing herself because she's woefully ill-equipped to do this. By the way, I'd say the same thing of the most progressive federal judge ever if they'd only had 14 hours of trial work. But she's woefully ill-equipped to handle these issues. So is there no intervening? Is there no way that circuit doesn't step forward? Say, come on, let's get somebody that actually can handle this.
So the Justice Department could ask for this to happen, but in that case, you would really be antagonizing the judge, especially if the judge is not going to be removed. So imagine if Jack Smith were to say, hey, we think you need to recuse yourself. We think you need to step aside. That would be a big affront to the judge. And then if the judge stays, then the government is already fighting sort of an uphill battle in front of that judge. They had to have known if they brought the case in Florida that this was an issue that was going to come of it. And I'm sure that some folks will say they had to bring it in Florida because that's where the crimes happened. Nevertheless, it is a a huge wild card. I just think it's, in terms of the entire matter, it's a humongous deal that this judge got it. And the clerk has said that they followed their normal procedures.
Well, maybe in the most important case in U.S. criminal history, maybe they don't just follow the normal procedure. Maybe they sit around the table and talk about it and say, this is extraordinarily important. And Judge, with all due respect, you have 14 hours of trial work. Do you really think you're qualified to do this? I don't understand.
And her ruling in which you were referencing, in which the circuit court really embarrassed her in many ways, the judicial branch.
14 days. I said hours. I meant 14 days.
The judicial branch, I think, throughout in the face of Trump, has largely, I would say, most people would probably say, held up pretty well, certainly compared to the other branches of government. And this will be a test of the entire judicial branch, and in a way that this could be the most high-profile case in American history. Like, this is a huge deal.
So, Andrew Weissman, is there any chance that there's a change here? I mean, you can see how this plays out. If a Trump-friendly judge, and Aileen Cannon, is moved off the case, you can already hear the cries from Donald Trump and the people around him that the fix is in. How do you see this playing out? Will it end up before Judge Cannon?
So far, that is exactly what the signs are. There's no sign that she's going to remove herself. But there are a couple things that could happen. We could see the Department of Justice move to recuse her, and then if she says no, to seek to go to the Court of Appeals. The other thing they could do, which I think is probably more likely, is wait for her first erroneous ruling. And given that, as you referred to, she's had two decisions that have been reversed in scathing opinions by a conservative 11th Circuit court, including, by the way, judges who are appointed by Donald Trump. So they do their duty, and they reversed her, saying that, as Joe said, that what she did was antithetical to the rule of law. They could wait for her to make another misstep, appeal that, and in that appeal ask that it be reassigned to a different judge. That's a route that, well, it's not common, does occur. And that would be the third time that she was reversed, not just in any case, but in this very investigation. So I think that is still something that could happen.
And I just want to underline this again. The 11th Circuit didn't just say that she made an erroneous ruling of law. They said that what she did undermined the foundational concept in American law that no person is above the law, and carved the exception out for presidents, and then said her ruling also did violence to the most basic notions of separation of powers. I mean, it's breathtaking. That's Andrew, that's as stinging a rebuke as any judge could have. I can't remember a more stinging rebuke.
Absolutely. A friend of mine who is a federal judge said to me that she would not have gotten out of bed that morning. She would have been so embarrassed. I mean, the real issue here is that was the first reversal of her did that. And people thought, okay, that's a brushback. She's going to learn her lesson, and she will now hew to the facts and the law. And it had no deterrent effect at all, whether it's because of bias, whether it's because of competence. But her second reversal continued because of the same conduct. And that's the reason I think it's hard to see that she's going to really change her stripes at this point. So basically DOJ could wait for another such instance and use that as the vehicle to get her removed from the case.
So